This will call to order the last meeting of the Criminal Law Subcommittee for this year. I'd like to be able to first handle a couple of more administrative actions. So Senator Serval has SB 489. That is similar but more expansive than my House bill. And so I would entertain a motion to conform this one to mine, and that we can then go to conference and figure it out.
So moved. Second.
There is a motion and a second that we conform SB 489. All those in favor, please vote on the electronic voting machine. Oh, no, I'm sorry. All those in favor of all those in favor of reporting this with a substitute. All right. Thank you very much. Now, I know I saw Senator Morrissey. There he is. Senator Morrissey.
Good morning, Mr. Chairman.
Can we start with...
good evening.
Good evening. Can we start with SB 811?
Certainly.
Thank you.
Mr. Chairman, members of the committee, 811 is now known as the non-jury sentencing bill. What this bill does is it allows the defendants to have the opportunity to opt for both a jury trial on the guilt or innocence phase and then allow the judge to do a sentencing. Of course, as everybody in this panel knows, right now the jury, if you elect to have a jury, the jury will do both the guilt and innocent phase and the sentencing. Right now in 44 states, the judge does the sentencing in a jury trial. In the federal system, the judge does the sentencing in a jury trial. My bill also allows, if a defendant chose to opt to have the jury do both the trial on guilt or innocence as well as the sentencing. That's essentially what it does. There are a couple of documents that I'd ask if staff would be so gracious as to pass out. I will.
While that's happening, are there any questions for the patron from the committee? Thank you. Hearing none, is there anyone here who would like to be able to testify in favor of this bill?
There's a number of people, Mr. Chair.
Okay. Hello. Come up and you'll be heard.
Good afternoon, Mr. Chairman and members of the committee. My name is Allison Powers. I'm the training enforcement attorney at the Indigent Defense Commission. I was also a public defender in the Fairfax office for more than 7 years. This bill brings fairness and equity to the fundamental right and protection of a trial by jury. As Senator Morrissey pointed out, Virginia is one of 6 states that currently has jury sentencing. And this bill would uphold the constitutional right to a trial by jury, as the jury trial provides the most meaningful opportunity to prove one's innocence. The present structure that we have actually discourages the exercise of the right to a jury trial because there are higher minimums that a jury must impose for certain charges, such as an example would be possession with intent to distribute. So we definitely think that the committee should consider this bill, and in terms of any funding issues that the committee may have, I think Senator Morrissey has passed out the schedule that we have looked over for the jury trial rates for the states that have reported them, and 2 of the states that have the lowest jury trial rate currently have judge sentencing.
Thank you very much. Please come forward. Hello.
Good afternoon, Mr. Chairman and members of the committee. I'm Ashley Shapiro. I'm here as a public defender for the City of Richmond. I've been with our system about 8 years now, and I'm also here on behalf of Justice Forward. We do support this bill as...
And Justice Forward is also public defenders.
Public defenders and court-appointed attorneys as well, so
right.
Criminal defense practitioners.
Right. Go ahead.
This bill would fix one of the very fundamental chills to exercising our jury trial rights. All too often when we're faced with the decision, when we have a client who wants to have their jury trial, we have to explain to them that there is a jury minimum and that if the jury gives that sentence, a judge is not going to suspend it. While legally speaking, a judge has the legal authority to do so. Practically speaking, and I believe it was actually Delegate Scott that brought this up in a previous debate, they don't. The judges don't want to disturb a jury verdict, and they will sentence to whatever the jury sentences, even if that is the exact minimum that they had to give. Just this week, I had a prosecutor tell me, you can either take this offer or you can take the 5 years from the jury. And we have a very good case, but it's a risk. And it's always a risk, and it's something that because it starts at whatever the jury minimum is, it chills his right to a jury trial, and we're faced with, we really think that we could defeat the charge and that the Commonwealth doesn't have enough evidence, but if we're wrong, it's 5 years. And the judge would give him less because they have guidelines or something like that. So this bill allows for a judge sentencing in that kind of a circumstance where if the jury were to convict, the judge has the guidelines, they have mitigation, they can hear from the victim, and the judge is then able to have all of the extra information to do the sentencing. So this would take away the fundamental chilling on our jury trial system, and we would very much support this bill.
Thank you very much. Especially if you have something new to offer as well.
Mr. Chairman, good afternoon. My name is Brian Kennedy. I'm the Senior Assistant Public Defender in Fairfax County. Just wanted to add that the U.S. Supreme Court has said that the default in our constitutional system is the jury trial. Our sentencing structure does not allow that to happen right now, and this bill would give life to the basic constitutional principles of a jury trial.
Now, excuse me for one moment.
Yes, sir.
The Fourth Circuit has also found that our current system is constitutional.
Yes, I'm not suggesting that it's not constitutional. I'm suggesting that in the Virginia Constitution, the Commonwealth has a right to choose a jury, the court has a right to choose a jury, and the defense has a right to choose a jury. And upholding that system as constitutional, the U.S. Supreme Court made clear that it is the default. The reason why that's constitutional is because under the Sixth Amendment and the 14th Amendment, our baseline is jury trial. Right now it cannot be because of how our sentencing structure is, and this would allow us to return to that original meaning of the Constitution.
Thank you very much. Please come forward. Hello, good to see you again.
How you doing? Mr. Chairman and members of the committee, my name is Randy Dillard. I represent the Virginia State Conference of the NAACP. We support this legislation, and we ask you to pass it. Thank you.
Thank you, sir. Good afternoon.
Mr. Chair, my name is Charles Willis. I serve as Executive Director of United Communities Against Crime. I'm the one that you see on the news that does all the prayer vigils, whether it's for state police officers that I've worked with families or whether it's the ones that are right in our communities. We're here to share with you that we do support this bill. We ask that you support it also. And being one that's on the front line of dealing with a lot of jury trials, I've been in cases where I've seen that with the opportunity that was been presented by Mr. Morrissey, Senator Morrissey, that this would be diligently to a lot of the families that are in need of this support. So thank you again for the opportunity to speak.
Thank you for coming down.
Good afternoon, everyone. My name is Ramin Fadahi. I am a Deputy Commonwealth's Attorney from the City of Norfolk. I appear before this body on behalf of the Commonwealth's attorneys of over 2 million of your citizens, the Commonwealth's attorneys of Fairfax County, Loudoun County, Arlington County, Albemarle County, and the City of Norfolk. We are here in support of Senate Bill 811. I would echo the comments of the previous speakers. We agree that while our current system does satisfy the minimum constitutional requirements that the Supreme Court has laid out, that it nevertheless imposes a significant chilling effect on the rights of accused individuals to be judged by a jury of their peers. I would add a couple of other points. The first is that as prosecutors, we are always concerned that similarly situated individuals be punished in similar ways. The jury system, according to the numbers that the Virginia Criminal Sentencing Commission has published for the last year, simply does not do that. The judges in Virginia have complied with Virginia's sentencing guidelines in their sentencings approximately 84% of the time. They have departed upwards about 7.5% of the time and departed downwards 8.5%. The compliance rate, if acknowledging that juries do not know what sentencing guidelines are far different in jury cases. A jury is about 50% more likely to recommend a sentence that by chance winds up below the sentencing guidelines. However, they are almost 5 times more likely to impose an aggravated sentence, an average sentence of 40 months, above what the median would be. That creates a concern for us. We also are concerned not just with accused persons, we are concerned for the welfare of our fellow citizens. Folks don't normally talk about jurors, but this current system, our position, is an imposition of an unnecessary psychological burden on our fellow citizens. We already ask our citizens to step off the street to hear grisly facts and to judge guilt or innocence. But when they do that, that is a very specific and circumscribed decision. To impose the psychological burden to recommend a sentence, to take away somebody's freedom when they know nothing about what similarly situated individuals are getting, and when they do not have the experience and the expertise of the judges that this body has so wisely chosen, is simply a burden that we believe our citizens should not have to bear. We are asking that that this body refer this bill to the full committee and that it conform our laws with the laws of 44 of our sister states and the federal government.
Thank you very much. Anyone who'd like to speak against this bill?
Good afternoon, Mr. Chairman. Nathan Green, Commonwealth's Attorney for the City of Williamsburg and James City County. I'm here speaking on behalf of the Virginia Association of Commonwealth Attorneys, the 115 offices that did not just have their voice heard. Mr. Chairman, we do believe that this is something that should be studied. It's our request that this be sent to be studied, much like the other our jury sentencing bills that have come before this committee thus far. There are, and I'm not going to try and be obtuse to the fact that there are issues and that there are some chilling effects that need to be studied. This committee has taken a number of them up and has sent them to be studied. Things like allowing a jury to suspend, allowing a jury to run concurrent, allowing a jury to know what guidelines or what the sentencing guidelines are. All of that is to be studied, and hopefully that will come out with a more robust and a better understanding of how juries should be used. But at this time, the eliminating jury sentencing today, we believe, would have a significant impact. Just in looking at our neighbor state in Maryland, we looked at offices both small, middle, and large. And every time we looked, the prosecutor's offices have more staff, more attorneys. More importantly, when we looked at Maryland versus Virginia, and one of the biggest differences being jury sentencing, the number of judges per citizen if we are to match Maryland and match judge sentencing, we would need 250 more judges to match up with the number of judges that Maryland has per citizen. For these reasons, and I did hear the individual from Norfolk. The idea that jury sentencing is bad for jurors, this bill doesn't eliminate that. This bill does still allow for the defendant to require the jury to do the very thing that he said is going to be against them. It's counter to the idea that the judge knows best, because really what it is now is the defendant gets to choose what will be best. He can choose whether he goes with jury sentencing or whether he will have the judge sentencing. You've heard from the public defenders, and they have said that what this bill would do would be to increase the opportunity for their clients to ask for juries, which is exactly what we are saying, that it is going to increase the numbers, and that needs to be studied. But you also heard that what it would also do is would be able to affect or help their negotiation position. And that's not what I think this policy is truly meant for. This isn't meant to help an offender to get a better deal. It's to make sure that our system is fair. And for that reason, I'm asking that this committee send this for study so that we can make sure that we do have a fair system, not one that just favors an offender.
Thank you, Mr. Green. And if we can just make sure that we we aren't repeating ourselves.
Yes, sir, Mr. Chair. My name is Mark Bernard. I'm from the Office of the Executive Secretary. And it's not necessarily we are opposed to the policy. We are not opposed to any policy. We don't take a position on that. We are concerned that this bill will cause a significant impact on the courts. The problem is we don't know the extent of that impact on the courts because we have no historical data from which to base anything upon. So therefore, we cannot attach any type of fiscal impact on this because we simply do not have the data. We would not know. We would expect a significant increase in jury trials that may require a significant increase in the number of judges. Additionally, if there's a significant increase in criminal jury trials, that may cause a delay in other jury trials on the civil side. If we need to bump a trial for speedy trial purposes in the criminal context, it may delay other types of trials. Again, though, we don't know the extent of the impact unless this matter would go to a study. So therefore, the court, although not opposed to any policy proposed by the senator, we would request this matter go to a study for those reasons. Thank you.
Thank you. Please come forward.
Good afternoon. I'm Michael Hurd, Commonwealth's attorney from Middlesex County. I've had 30 years experience in practice of law, including defense, 13 years, and prosecuting for a total of 17 years. And as Commonwealth's attorney, we talk to each other a lot in regard, well, sometimes in regard to on the website, emails that is. And I've never really seen as many comments about legislation as I've seen among Commonwealth's attorneys about this bill, because it means so much to us. And overwhelmingly, the response was no, and for a number of reasons. For one thing, the impact that it's going to have. And I'm a one-person show. I do not have any assistants. I put in a lot of nights, weekends, time, and extra time on the job. And if you're going to have jury trials for all, we need to strongly consider this. And I agree with Mr. Green in regard to that really needs to be studied as to the impact that's going to have. The other thing I thought of, even before I thought about the impact on the players in the system and the defendants, is the public, which is one thing to talk about what other states do, but I've talked to a lot of jurors after they've served, and they take it very seriously. And to say that they're being disenfranchised and that we don't really trust them to make the right decision and that we're taking away their voice, that they can hear part of the case, only part of it, but we don't trust them to make the decision as to sentencing, is taking away the right to one's trial by their peers, because it's not giving the whole trial to them by their peers, only a part of it. And that is not the way that we've done things in Virginia, and for good reason. I want to give you a little example of how juries can keep you honest. I learned a lot in a jury trial on destruction of a sprinkler system in the jail, which is actually a felony. And I learned that jurors have the pulse of the community in that type of a case. They didn't see it as a big deal. If we went strictly by guidelines, strictly by what everybody does on property damage crimes, the guy would have got a much higher sentence from a judge. But the jury thought otherwise because they have the pulse of the community. They can decide what they seem as important and what they don't. They take the emotions of people into account in regard to what they see, positive and negative, about a defendant at sentencing. And I ask that you consider all of that, please, that this is going to have a big change on our whole system.
Thank you very much. Hey, first time today.
Hey, Mr. Chairman. Lieutenant Gilbert with the Virginia Sheriff Association. I've been instructed to, the Sheriff's Association opposes the bill for the fiscal impact alone. It's a lot of money, so that's it. Thank you.
Thank you very much. At this point, Senator, you have your last word.
Thank you, Mr. Chair. A couple of points. I heard many folks talk on the negative side about the chilling effect. Mr. I believe it was Green, said that I acknowledge that there is a chilling effect if this bill were to be passed. That should be a full stop right there. Because if we're going to chill a defendant's right for any right, then we ought to stop and re-examine it. There is only one area in the Constitution, state Constitution, where it says a right is sacred. And that is in this right to a jury trial. Our state Constitution says trial by jury is preferable to any other and ought to be held sacred. That word is not used anywhere else. The prosecutors that spoke are correct. There will be a change, and what has happened is this. A prosecutor will say, here's my plea offer. Take it or leave it. And they love that power. And when they say that, a defendant who may in fact be innocent decides, you know what, I'm not going to let this jury decide because I'm worried about getting a sentence for 10 years. That chilling effect is deplorable. And that's why they want to keep it. A couple of other points. I heard the mention of cost. You know, I really find it amazing that we are talking about a right enshrined in our national constitution and in our state constitution, and we're going to debate cost about it. But let me address that. I gave you a document earlier, and it showed the jury trials. And those are the 26 states that have submitted data. It's not all 50 because all 50 didn't submit it. But let's take a state like California, which is not actually a bastion of liberalism, of conservatism. In California, they had 160,538 felony dispositions. This is where the judge did the sentencing. And it was done in 3,900 cases, 2.4%. No explosion in jury trials. Interestingly, look at the bottom there where Connecticut and Nebraska, they have judge sentencing, and they are the two almost lowest where the defendants, where it's a felony jury trial rate at 0.7%. The executive secretary from the Virginia Supreme Court said, well, we don't have empirical data. You have it. It's right here. And there is absolutely no evidence whatsoever that there will be an explosion in jury trials. And with that said, let me share the following comment. When I was a Commonwealth attorney in Richmond 30 years ago, we had judges were doing approximately 60 jury trials a year. They were doing a lot. And that's when we didn't have bifurcated juries. And the prosecutors, we had 17 prosecutors in the office, the largest in the state. Now we have 34, there's 34 prosecutors and half their caseload. What it might mean is that the prosecutors might have to work a little bit harder. So what? You're protecting the defendant's rights. The judges may have a few more trials to do, again, respectively, so what? We're protecting defendants' rights. A couple of other points that were mentioned, and that is that
I think you probably also have some questions from people up here as well.
All right. I'll end with this comment, and then I'll take questions. I heard the gentleman say on behalf of the, I think he said 1.5 million or 2 million people that weren't recognized. This letter that I got from the 5 prosecutors, Commonwealth attorney, I didn't solicit it. It was handed to me. I had no idea that it was such a topic of conversation among VACA. Glad that it is. It should be. Because you have the right and the opportunity today to really transform criminal justice reform and do what 44 other states have done. Mr. Chairman, I'll answer any questions that you have.
Delegate Carol Foy.
Thank you, Mr. Chairman. It's not so much a question as a comment. I just want to be very clear that this bill is one of the most important and impactful pieces of criminal justice reform legislation that we could potentially pass this session. And there is a reason that Virginia is 1 in 6 states to mandate jury sentencing, because it is draconian and flies in the face of a person's fundamental right to a fair trial, and I'll include a fair sentencing. Judges have access to sentencing guidelines and the experience of sentencing that a jury does not. And I keep hearing that we need to study. But there is no need to study what is fundamentally wrong and unfair. And I've even heard concessions that the current system isn't fair, but let's study it anyway. 44 states are doing this currently, but let's study it anyway. And I'll end on this. I just want to remind everyone that justice delayed is justice denied. And this is something we can do and that we should do. And I would like to thank the patron for bringing this bill.
Thank you.
Delegate Scott.
I just wanted to echo, I'll adopt all of her great comments, but what disturbs me is when I hear folks who are against this bill say that it's too expensive. How expensive is 1 day of liberty? I mean, we're talking about people's lives. We have, based on the data that I see from the Criminal Sentencing Commission, less than 1.3% of our cases that have guidelines are going to jury trial. That is just, we may as well just take away jury trials. 1.3%. We may just well stop having jury trials. That's what we're doing now. The chilling effect is so strong that only a very, very small percentage of people even go to jury trial. Now, the data that we've been provided from the study clearly says that juries have much more aggravating factors when they sentence. They sentence basically a fancy way of saying, man, your sentence is going to be much higher if you go to jury trial. When you have a judge sentence, the likelihood that it's within the guidelines, which means that similar crimes are punished similarly, are very, very likely. Very small aggravating factors and some mitigation, in fact. So what I think this bill is basically, some folks say, fairness is expensive. Doing the right thing is expensive. I think we can't afford not to do this, and we can't study it anymore. We have all of the data. We have what other states do. We have the sentencing, the crime commission, or the sentencing commission that's giving us data. We have all the information that we need. We just have to make a decision: do we want to do the right thing? Because we're one of 6 states that's not doing it right. So if we want to continue to do the wrong thing, I'd urge you to vote no against this bill.
Thank you, Delegate Scott. Are there any? Well, this committee operates by motion. I'm sorry, Delegate Watts. You were on the speaking queue.
Okay, so I'm sitting here at least 15 years on the Criminal Law Subcommittee, and as I so often have to confess, the non-attorney. So I try very hard to process what I'm hearing, and I think my attendance probably deserves a star, because I'm probably always here. And my frustration is that I have learned things in the last week about jury sentencing that I had never heard before, ever heard before. And here we are in essentially the last week, clock will be a Saturday. And it's coming before us rather than having had the opportunity, as we normally have, to have had a House bill, plus a Senate bill, plus the fact that I know this session, by some people's perspectives, we have done a lot of different stuff that they never expected. But in my experience, most of these things have, in fact, had a long history of coming before us that and we are ready to go. On this one, I honestly have not heard it before committee. I'm listening to the Commonwealth's attorneys that there were bits and pieces, but the actual issue of jury sentencing versus judicial sentencing, I honestly haven't heard. Now, with all of that, I am extremely disturbed about the fact that the jury does not have access to the criminal sentencing guidelines. I've followed that issue prior to coming back into the legislature when it became the direction of the country in the 1990s. And we don't use it with jury sentencing. And that I was just appalled to learn that. And then, since I have followed the use of the deviation from the guidelines as we're looking at the record of sitting judges, this is something that I've always looked at. To what degree and why are you what is your record of deviation, as I think they are, in fact, guidelines, and it's something that I want to have the judge be accountable for how they approach those guidelines, and yet we're not sharing them with the jury. So now, having said all of that, and there's still some other things that are rattling in my head, just because of the fact that this is the first time that this very important thing has come before this subcommittee, I would make the motion that we carry over for study, and I promise you next year that that with all of these things being properly before us, that, believe me, from there's a number of reasons that I could vote for it immediately, but I don't feel comfortable that we really have all the information before us. Now, I realize that now I have spoken and I really had wanted to be recognized for a motion, but I would move that we carry over Crime Commission study and as carryover its active legislation as it comes back before us.
Mr. Chair, may I address that very briefly?
Sure.
Thank you. I could not have said it any better than Delegate Carol Foy, who quoted Martin Luther King, "Justice delayed is justice denied." And I would tell Delegate Watts at first, don't apologize for not being a lawyer. That's probably a good thing right now. Number two, if we delay this for a year, think of the number of defendants who will have justice denied because in this intervening year or 13-month period, they go into a courtroom and they're told, take this plea deal or not, and they have the prosecutor said it. The prosecutor said, Mr. Green, I agree, there's a chilling effect. Right there, that should cause us to stop and say, we're not going to deny or delay justice. So I would hope that the panel would just defeat that motion.
Thank you very much. Is there a second?
Second.
There's a...
Did we have a motion to report? Is that a superior motion? I'm sorry, parliamentary.
It is a superior motion, but there was not a second to that. So there was a motion.
I seconded the motion to report.
Okay, wait a minute. Now, wait, I'm sorry. Now I'm learning here.
Delegate Watts had her light on, so the motion was recognized.
Move to continue over or carry over to 2021 is a superior motion. I did not know that.
Speaking to the motion.
Delegate Scott.
Again, I would urge us not to continue this over. We have data in front of us. We have information in front of us. We have the Sentencing Commission's not an old report, the 2019 annual report, where we basically have identified the fact that we only have 1% of jury trials. 90% of all sentencing guideline dispositions, 90% are pled out. That is a huge amount of leverage because we have such a weak jury trial system. So we can't, the other way should happen. We should pass this now and study what we can do to make it better and then make our jury system more robust. We do not have a trial by jury system right now. We're basically admitting failure now if we continue to go with this process. We do not have a fair jury trial system in the Commonwealth of Virginia right now.
Thank you, Delegate Scott. The motion is now before us. Clerk will open the roll. Oh, I'm sorry.
Parliamentary inquiry, Mr. Chairman. There was a move to report, and Delegate Scott seconded.
I didn't hear the second.
I did second.
Was that the first motion? Okay.
That was the first motion.
Well, I guess that was motioned, and then there was a substitute motion. Isn't that right? Is that right? Okay. Okay. Learning new about parliamentary procedure. So then that would be a substitute motion. Continue over is a superior motion to that. And so if the carryover fails, then we will have the motion to report. I want to do it on...
Mr. Chair, in all due respect, I don't know if I heard a second to carry over. Oh.
Thank you, Delegate and Senator Morrissey. You do have 810, though, which is similar. Maybe we don't...
Mr. Chair.
Yes.
I do want the senators to know that will be part of, it'll be carried over, but I need to clarify, was that So it's okay, because I didn't hear the study part.
Oh, and we just passed that through rules
perfect.
yesterday.
So, I mean, Senator Edwards
Yes.
does, right, we just, rules just, and
Right.
that will be a priority.
Yes,
Thank
sir.
you.
Senator Morrissey, 810.
810 requires that the jury be given applicable discretionary sentencing guidelines. I'll adopt the argument from Delegate Watts, ask the body to pass it.
All right. Anyone who wants to speak briefly in favor or against? No? Okay. All right. Well, then the bill is before us. Do we have a motion?
Mr. Chair.
All right. I'm sorry. Delegate Bell.
I didn't want to let the motion go, and then I have a question for the chair.
There was a motion and a second to report.
Okay.
Delegate Bell.
All right, Mr. Chair, I'm trying to, we have already passed, and I think passed the Senate, the Lindsay bill.
That's right.
Okay. And then last night in rules, I'm not on rules, but I was there, and I gather you took up or I was there when you took up a study about jury sentencing generally from Senator Edwards.
That's correct.
Okay. And then we've had, and I've lost count, but 4 or 5 give the jury different options or more information bills.
That's right.
Okay.
So just so everyone is clear, we've already allowed the potential jurors during voir dire to know what the category of offense is. And this would be on the back end during the sentencing phase, also allowing them to have the sentencing guidelines. One's front end, one's back end. Anything further from the committee? All right. Clerk will open the roll. Bill report 6-3. Senator Morrissey, we now have, I'm going backwards, 807. Larceny, subsequent offenses. Senator Morrissey.
Thank you, Mr. Chair. This bill eliminates a Class 6 felony that's applicable to a third or subsequent offense of petty larceny. And as you know, person is charged with a third or subsequent offense, they face a felony, but it's 1 to 5 years. The genesis of this bill was a article that I read in the front page of the Richmond Times-Dispatch. A woman died in prison after being sentenced to 3 years for stealing $45 worth of suntan products. She had 2 previous convictions for petty larceny. Her very, very competent and qualified public defender observed and identified her mental health issues, got her into a program, Ruth's House or something like that, and the judge, though, at the prosecution's urging, gave her 5 years with 2 years suspended. So she was doing 3 years. Now, since we heard so much about cost on the previous bill, we're just going to charge the state on the average, it's $42,000 a year capital cost and incarceration. So that's $126,000 that we'll spend in state money to incarcerate somebody who is getting no mental health treatment in jail and stole $45 worth of suntan products. Sadly, she died in prison. This bill removes the enhanced Class 6 felony from the provision of 18.2-104. And the jury or the judge can still give her 30 days in jail for this offense, but it can't give her 5 years. I'll try to answer any questions.
So just as an initial basis, we have a bill that Senator Serval and I have that's in conference right now, or about to be in conference tomorrow, that would allow a defer and dismiss in those cases in the first instance. So
I'm all in favor of that one, too.
I like it. Thank you. But so right now, with the passage of that, it would really be the fourth offense that someone would actually be facing a felony penalty. And we are now also raised the felony larceny threshold to $1,000. And so, I mean, under this, you could perennially steal iPhones, and there would never be a felon charge. I'm not particularly attached to 3. I don't know what the correct number is. Maybe it should be 4 or 5 or 10. I don't know. But I mean, we always talk about theft in terms of big, large box stores like Walmart, but you can also steal stuff from my yard, you know, like Mr. Mutnick's new riding lawnmower. Are there people who would like to speak on this bill?
Mr. Chair, let me address that. It's a very valid comment. First of all, when I spoke earlier about the 30 days, let's be clear, that's the minimum 30 days. They could also be given up to 12 months for stealing that product. Second, I don't doubt that somebody that is either in the throes of a mental health crisis or has an addiction that they are so desirous of getting off their back, they may steal a 4th or a 5th time. And maybe it's appropriate to put them in jail. I actually believe that we should have a mental health docket, and that's where they should go. And fortunately, that bill got passed.
That was a great bill.
But here, this is a singular point that I'm making. Should we take away the option to give somebody in 5 years in jail, even if they're have been convicted of that offense multiple times? I simply don't think so. I think it's draconian.
Well,
let's hear from you, and you were
no, that's fine. I want to make sure that everyone has their say. Is there anyone here who would like to speak in favor of this bill? Anyone who would like to speak against it? You got one coming up behind you.
Of course, one thing to bring out is prosecutors do have what's called discretion, and we use that in regard to the facts of a case. And one of the things we use as a tool also is in regard to if someone is a repeat thief, then that needs to be looked at differently than someone who's done it just a few times and has a mental health issue or that sort of thing. I want to let you know what type of case I usually see in regard to the third offense larceny and where I usually use that. And that's the people who are stealing the copper from churches. They'll take away the copper tubing, they'll cut the wire, the tubing to the AC units and HVAC units and the propane tanks. And we have one case just recently where someone did that to 7 different African-American churches in the county. And he's been convicted of larceny many, many times. Before that, the last time I had someone do that in regard to one of the churches, he had been convicted in Tidewater of over 20 different larcenies. And it comes to a time when, enough is enough. And I agree with Delegate Mullins is what is the magic number? You may could play with that a little bit, but I encourage you to not do away with having a larceny as eventually a felony when you do it plenty enough times when it should be enough is enough.
Thank you very much. Before you go, I think
Mr.
Delegate
Chair.
Herring and Delegate Scott had some questions.
Yes, I have a question for you. At the beginning of your comments, you talked about discretion, and that's my concern. I would think, and it's just me, that someone who continues, that there may be a mental health problem.
Yes.
So let me just speak for myself. It's my concern that now prosecutors use their discretion to say we are dealing with somebody with a mental health issue. So what will help me get comfort that that's what's happening across the Commonwealth?
Okay, one of the things that I like to keep track of is resources that are available, whether it's someone who is having a substance abuse issue, which is a majority of our larcenies, or people with substance abuse issues. We have to know what we're dealing with. How is the best way to resolve someone from doing this again? And that also is something we look at with mental health treatment. My victim witness person has a big background in mental health. She used to teach at MCV Medical Center and counseled at all the prisons, women's prisons in Virginia. And so we're very big into looking at what can we do to try to stop this person from doing this again. Jail isn't always the option. Mental health is something that has to be looked at. Substance abuse counseling has to be looked at too. So we do take all that into consideration.
But are you able to say with certainty that other Commonwealth attorneys' offices do?
Well, as my wife says, I don't get out of Middlesex County very often, so I can't say what a lot of other people do.
Appreciate it. Thank you. Thank you.
Thank you.
Delegate Scott.
Yeah,
that
was going to be it was not necessarily a question, but a comment.
Absolutely. Delegate Scott.
Back just responding to his comments, I have an issue with this discretion thing. At one point, we say that we can't do some things with juries because that's going to destroy something, but now they say they have discretion. And that's the same discretion they have to have a 90% plea agreement rate in our state. So I don't trust that. That's one, Jermichael Mitchell, who is dead, who was for stealing a candy bar and a Sprite. He's dead now because of discretion. So what I think that this is an opportunity, another opportunity for the Commonwealth to correct some wrongs, to fix problems moving forward, which is what we should be trying to do. No one should go. I heard the gentleman say that, well, they keep stealing. Normally, if they're stealing that, it's going to be more than $1,000, which is what we are now. And at one point, it was $500, and before that, it was $250. Right. So we're not talking about a whole lot. If they're stealing a cell phone, I don't know where you're getting the iPhones from, but if you're getting them under $1,000, text me and let me know, because they're very expensive. So I think that this is an opportunity for us to fix and move forward. I thank the patron for bringing this bill.
Delegate Scott, I love having you on this committee.
Let me also address the point that both Delegates Herring and Scott said regarding discretion. The Commonwealth Attorney who just spoke, and I say this respectfully, talked about the discretion of Commonwealth Attorneys. Let's be clear. That same discretion caused VACA, the Virginia Association of Commonwealth Attorneys, to oppose drug courts in 2004. It's the Commonwealth Attorneys who are opposing, as Delegate Watts said, the inexcusable, indefensible position of not giving the jury sentencing guidelines. It's the Commonwealth attorneys who use the discretion not to let a jury know during voir dire that this is the range of punishment. For aggravated malicious wounding, you face 20 to life. And since we have shared vignettes, let me share a vignette with you. There were two people that were fighting. There was a fist fight. There was no weapon. Cut above the eye, there was a slight scar. All right. Because aggravated malicious wounding says there's permanency, and permanency could include scarring. I'm almost done.
Okay.
That they got an instruction for aggravated malicious wounding. And that prosecutor then argued in closing, you heard from the expert, it's from the doctor, there's permanency. You heard from the expert that scarring, you must give them aggravated malicious wounding. That jury goes in there. They don't know the range. They find him guilty of aggravated malicious wounding, and they were thinking, okay, maybe it's a 6-month sentence, 2 months. They get the instruction back in the second phase, and they got to give the person 20 years. That's disgraceful.
Senator.
So much for discretion.
Senator, we just passed those bills that fix that situation.
Oh, thank God.
I mean,
and I would say that respectfully.
Many of them were carried by you. I mean, you're getting a tremendous number of bills out of this committee, which is usually a killing committee. So.
Most important one I didn't get, but I appreciate you saying that.
Yeah, no, I mean, you're changing the criminal justice system in your first year.
Second.
Motion and a second. All those in favor? Vote on the electronic voting machine. The bill fails to report. Now, you have a really good bill. I like this next one. I wish I'd carried it. 798.
Thank you, Mr. Chair. Thank you for the comment. 798 changes the law associated with DUI only to say if such person was driving or operating a motor vehicle on a highway. There's been a very robust discussion in Senate Judiciary, and I'm not sure if you've heard this in House courts, but here's the problem. As you all know on the panel, you can be convicted of drunk driving under the following scenario. You decide that you're intoxicated you may have gone a mile and you pull over, or you may even not even leave, but you decide you're not going to drive, and you get in your car and you turn the heat on, and you're going to sleep it off, and you could be arrested and charged with operating.
That's not this bill.
This is, well, I'm giving you an example. This one deals with if you, under 798.
This is third offense, driving on suspended, 10-day mandatory. I'm sorry, this is a 10. Oh. Yeah, okay. Yep.
798.
Right, but go ahead.
Any person who drives or operates any motor vehicle on any highway, that's the change. It includes any highway. So, and I was perhaps too long-winded, Mr. Chair. Here's an example where somebody can be convicted of drunk driving. They're in their own lawn, on their own house. They're on their tractor.
We've had that bill every year for the last 3 or 4 years, and I've come to find out that some people think that it is their God-given right to get drunk on a lawnmower, which I had no idea about.
Well, I can't speak to whether they think it's a God-given right, but I know this. If they leave their house and they go out and they just listen, turn the radio on, and they've had a beer or are drinking one, and they have no intention of driving anywhere, that they could be charged with DUI is, I think, is nonsense. If they're on their golf cart on their own property, DUI. If they're operating a forklift at their job and they not drunk. Yeah. Right. And then they have they're charged with driving on a revoked operator's license because it was previously revoked because of a DUI. It's a very, I think, practical approach. It just changes it to you have to be operating a motor vehicle on a highway.
Yep. And I'm sorry, when I was saying, man, I really loved the bill, was Senator McClellan's 711. That was the one that I was really excited about. I don't have strong opinions on yours, one way or the other.
That's okay.
Mr. Mutnick and then Delegate Collins.
Mr. Chairman, just to point out that I think this may not be a necessary change. In 2013, the Court of Appeals in the analogous bill or analogous statute of 462391D, which is actually just the driving revoked on multiple DUI convictions, held that the word highway actually should be read into the bill or into the law as a requirement. And they cited a Supreme Court case that came from, it's the Perlman case that was actually from 1957 that states that the Virginia Supreme Court has said that the driving under with this driving revoked under these circumstances has to occur on a highway anyway. And so that's from 2013. Now that is an unpublished bill and unpublished opinion, and it does not deal with this exact statute. It actually deals with a worse scenario. But in that case, the court said, read highway into it, that it has to be on a highway, which doesn't necessarily mean public road, just means a way open to the public.
So, Mr. Chair, just my point. We regularly in this body, in the General Assembly, will follow stare decisis and then codify it. The fact that the Supreme Court has said it, albeit in an unpublished opinion, is all the more reason to codify that significant change.
Delegate Collins.
I think Mr. Mutnick, and I'll just follow up with that. So as I remember, that was the case of driving while intoxicated on a parking lot.
This actually is this is not dealing with driving while intoxicated at all. This is dealing with driving on a revoked license. And yes, this did occur in a parking lot in a strip mall, and the court overturned the conviction for driving on a revoked license based on this.
Right. So this is. So when we say it's under 272, this is just so we're clear. This is not a DUI. This is you've already been convicted of DUI. You're driving outside your restricted, or you have never been, or you're still within your suspension period. Okay, That's correct. I want to make sure we clarify. So this is someone who's driving sober, but currently suspended DUI related.
That is correct. If they are drunk as well, then the DUI
if they're drunk as well, then the DUI would apply in the parking lot of their driveway or mowing the lawn.
Delegate Collins, I appreciate Delegate Collins saying that because that is absolutely true. The person is sober. The person is driving their forklift sober. The person is driving their golf cart sober. They can be convicted of driving on a suspended license, having previously been convicted of DUI. It is, maybe to me, and sometimes I see things differently than others, Mr. Chairman, but driving, you mentioned God-given right to drive drunk. I do think you have a God-given right to drive your golf cart on your property sober. You have a God-given right to go to work and drive that forklift sober.
Delegate Watts.
And I agree with what you've just said. So I'm just making sure that we haven't gone too far. Because as I'm reading the definition of highway that is referenced in the bill, it's the entire width between the boundary lines of every way or place open to the use of the public for purposes of vehicular traffic in the Commonwealth. Then it says including streets and alleys for law enforcement purposes. So my issue is, so is the parking lot of the school, is the driveway to the school, all of those, I read that that's also what you're including. I agree with what you're saying about the forklift, the farm machinery, all of that on your own property. But how does this tie
Certainly.
into your
That's a
concept?
great question, and that's often interpreted differently by general district court judges. Is the parking lot, the thoroughfare right in front of the strip center, is that a highway? And many judges will say, yes, it is. It
It's
is a
open
highway.
to the public.
Yeah.
Delegate Bell.
Could I have a question for staff? So, as she often does, Delegate Watts has prompted some thinking. I welcome the senator's thoughts too, but more this is for staff. So this is a much litigated, what's a highway is a much litigated thing, and the parking lots is what she's described. And my recollection is that an enforced no trespassing sign makes a parking lot private, but it has to be enforced.
Yeah, that's correct. It has to be
a casual sign, no loitering sign doesn't count.
That's correct. It's a degree, and as the courts has stated in very plain language that whether something or not is a highway is the degree to which the way is open to the public use for vehicular travel. And so some of the things that the court has pointed out that make a parking lot a public highway would be traffic control signs that have stop signs or lines that point which way traffic goes.
Mr. Chair, so a 7, I'm just going to go through a couple of examples. A 7-Eleven lot where people come and go has a no loitering sign would be a public highway in most cases.
In some cases, I know that there are a couple of cases where gas station parking lots have been held as private.
That's what I was going to say. And then the next
highways.
would be apartment lot where there's a super, or where the gas station guy comes out and says, you can't park here, this is private property. It's enforced in some way, would not be a highway.
That's correct.
Okay, so then, Mr. Chair, let me ask staff though. So thinking of scenarios, a guy does donuts in the parking lot of his apartment complex, just round and around, and it's one of the apartment complexes where they have some notion of parking spots and it's enforced. That would not be a public highway.
That's correct. That would likely not be a public highway if it's enforced that there should not be able to be in there.
Okay, and then you've got this case that I've certainly never reviewed. Could you? I'm not saying could you maybe just, if does this in fact codify existing court precedent? Does it make it broader? Does it make it narrower?
Mr. Chairman, I think in my opinion it doesn't codify it because the court has never addressed it for this statute, and so the court has not addressed specifically. What it was addressing was in 462391, which is an analogous statute for multiple DUI revocations. The word highway is not found in that statute as well. This case, which is Villarreal from 2013 out of Chesterfield County, and this was a case where the parking lot had multiple no loitering, no alcohol, no trespassing signs, and they were enforced. And so it's not codifying court precedent because the court has never addressed it in 182272. However, it's a similar statute where they did read it. And then Perliman was the old, before it even was, Perliman was the HO statute way back in 1957 that they were addressing it, where it didn't mention highway, but they read highway into it.
Okay. Mr. Chairman, let me just say this in answer to Delegate Bell's question. Driving on a suspended license now has to be a highway. But in this code, you can be convicted of driving on a suspended license, having it been suspended because of a DUI conviction, and you can get up at 8 o'clock in the morning, sober as a judge, get on your lawnmower.
I've known some judges who weren't sober.
I know. Cut your 4 acres of grass, fulfill your honey-do list, and then be charged with an offense of driving on a suspended license, having previously been convicted of drunk driving. I mean, you're sober. Or your wife could say, well, I want to watch Jeopardy. You go out and listen to the radio in the car. You go out on your own property and you listen to the radio. Stone sober again. And you're convicted of driving on a suspended license.
Senator, sometimes you're talking past the sale.
Well, I thought I did that before, but my bill got defeated. So, all right, I'll stop.
We have to take public testimony.
Oh, sorry.
All right. Anyone here who wants to speak on this bill? Is that okay? Please come up.
Good evening, Mr. Chairman, committee members. My name is Derek Davis. I'm here on behalf of Virginia Association of Commonwealth Attorneys. Let's be clear about what this bill does. This bill lets somebody who's been convicted of a DUI, that the court has found guilty of DUI and has said that they don't need to be driving, they're dangerous behind the wheel, we're suspending their license for DUI related. So you may think, yeah, I don't care if somebody drives their lawnmower around the back of their farm or their tractor, and that's fine. But that's not all this bill includes. Like it was alluded to earlier, this is going to include a lot of private school parking lots, roadways could be included in there, a lot of apartment complexes. Just recently, the court upheld that the Busch Gardens parking lot was private property. That's a couple 100 acres of roads, parking lots. That's a place where you can go there. They serve beer all day long. You can come out, thousands of kids running around, and you don't have to use your ignition interlock in that parking lot anymore after your DUI conviction.
So I will also say it's a wonderful place to take your family, and is right there in the 93rd District on the Virginia Peninsula.
That's correct, and I'd love to be able to continue going there feeling safe that people aren't going to be driving around when they're not supposed to.
Interestingly, you wouldn't be able to leave the parking lot, though, because that would still be, and you're going to end up on Route 60. Well, I assume many people go to Busch Gardens sober and should not be driving after being there. We also have a great brewery.
And Mr. Chairman, I'll tell you, so I'm from Surrey County, one of the most rural jurisdictions we have here. We have more people with tractors and riding mowers than we do vehicles, I think. We've got 2 lumber mills there where people drive forklifts around all day at them. And I can tell you, I have never seen somebody come in court that was charged with driving revoked on their tractor, on their lawnmower, or on their forklift. This bill is trying to solve a problem that doesn't exist, and it's going to create more problems than it's going to solve.
All right. I believe now that we've taken thank you. Now that we've taken public testimony, I think there was a motion and a second to report. All those in favor or against, vote on the electronic voting machine. All right. Your bill reports 7-1.
Thank you, Mr. Chair.
All right. So I've been asked that we do Senator Boysko's bill next.
Hello, Mr. Chairman, members of the subcommittee. Today I bring before you SB 667. It's known as the Good Samaritan Bill. It provides individuals who call emergency medical attention when they are overdosing or when someone who is overdosing shall not be arrested for the purchase or possession of alcohol, controlled substances, marijuana, or paraphernalia. And everybody here knows that unintentional overdoses are a leading cause of preventable deaths. In fact, more than 1,500 people died in Virginia last year from drug ODs. I want to clarify what this bill does not do. SB 667 does not change or restrict the use of evidence to investigate, to arrest, or prosecute other people or other crimes. It does not change procedures for handling of evidence by law enforcement. It does not protect anyone from a crime of possession with intent to distribute. This is a life-saving bill, and I'm asking you to pass it for 3 reasons. First, in Virginia, we know that friends often don't call for help for fear of being arrested. We all know those personal stories. Somebody was dragged out and left in the bushes. Under the current law, both the witness and the person overdosing may be arrested and prosecuted. And data shows that bystanders are 3 times more likely to call 911 when they know that there is a safe reporting law. This is an evidence-based bill. Second, in an overdose emergency, every second matters. And I have a lot of people here in the audience who want to tell you their personal stories.
And we have this bill or other bills like that every year, and we do some of them. And then advocates come back and want more and keep expanding it. So I would like to, in fact, we had almost, well, not exactly the same bill, but very similar bill that was carried by Senator Carr earlier, which was laid on the table. There are many people who would like to be able to tell their personal story here, and I want everyone to have an opportunity to be able to be heard, but I don't want us to, we only have until 6 o'clock to finish this docket. So I would like to limit discussion on this on both sides to 5 minutes.
Thank you.
Thank you.
Okay.
So, all those in favor of this bill, please come forward and be heard. Remembering that if you speak for too long, then the people behind you cannot.
Thank you, Mr. Chairman. I'm John Shenholzer, President and co-founder of the McShin Foundation, a recovery community organization here in Richmond. I'm also a person in long-term recovery from substance use disorders. For me, that means I've been clean and sober 37 years, 6 months, and 18 days. Who's counting? This bill, and I got some people here with me to support me, but they're not going to speak. But if you're in support of what I'm saying, please stand up. Y'all stay standing for a minute. Every one of these people knows somebody who overdosed and died because somebody did not call 911. And many of these folks have overdosed themselves and they've survived. The problem is, Delegate Boysko, in the Senate side, we presented all the evidence we needed to prove that this bill will save lives and increase public safety, as well as increase recovery in the communities. The problem is, opiate withdrawal is the most severe mental health condition a human being can probably go through. And the biggest fear is detoxing without medication-assisted detox. And the only fear bigger than that is to do it in a jail cell. Now, in Virginia, it's not consistent across the state. Right now, if you overdose in Richmond, please come. They do a report. They send you home. They might take you to the hospital. The hospital streets you. They tell you to go to the community service board. They street you. But you go out into another rural county, and the sheriff might arrest you and put you in jail, and you detox. There's no consistency on how we're treating addiction. I think you're well aware of that. Given the fact that we can save so many lives, get that phone ringing, Virginia is heading toward the direction where at every overdose scene in Virginia, probably within a year, you're going to have a peer navigator, somebody in recovery there to talk to that person, engage them, and get them in recovery. So Virginia's on the way to creating this awesome recovery support service system, but they're not there yet. The criminal justice system for the last 20 years has had an opportunity to do better and do good and make it consistent. They haven't done so. But I'll end with this. Last year, y'all had a bill come through called the Dillon Law, where a young lady overdosed and died. That girl, Dillon, the day before she died, was offered recovery. We're trying to get her in recovery. And she said, I can't go because I'm confidential informant for the local police authority. I have to go buy some heroin. I got to stay in the game. I can't get clean because I'll go to jail. And then I have to detox in jail with no resources. Our people are being exploited as the system stands today, exploiting a human being in their most crisis moment of their life, facing the worst pain in their life, and we don't have consistency in the state of Virginia. So this bill will allow consistency, will allow the thousands of recovering people across the state of Virginia to engage and help people and create a healthier community. This is a very good evidence-based bill that will save lives, increase public safety, and make us all better off in the community. I thank y'all for coming down here and being patient. And now you see what they got to sit through for 8 weeks in a row.
Okay,
So
it's worth it. It's worth
thank
it.
you. Y'all
It's
can sit
worth it.
down.
I don't want to see somebody die.
Any questions?
No. You have now a minute and 30 seconds left on this side. Perhaps.
Well, I don't want to take up any more of your time.
No, nobody else would get to speak if.
Oh, okay. Oh, I'm sorry. I'm taking this time. Oh,
That's what I said to begin with. That when you speak too long.
Hi, thank you.
Hello.
I am Denise Carl from Henrico County. I have a statement here from Emily Westerholm, who's with Health Brigade, who could not make it. Please support this bill, which protects individuals from arrest if they overdose or seek help for someone else overdosing. It will allow more people to seek the medical care they need without fear and will result in fewer individuals dying because people are too afraid to call emergency services. We know that Good Samaritan laws and knowledge of them make calling 911 more likely. A 2018 study showed that the odds were 3 times greater of calling 911 when the responder knew there were Good Samaritan laws. The Senate version of this bill corrected the House bill version by giving law enforcement protections from wrongful arrest. It saves Virginians' lives. Please support. And for me, I know individuals whose children or family members have been saved by a 911 call. And unfortunately, I know those who have lost their children or loved ones because a 911 call was not made. As a parent, that's almost too much to imagine, so please help us save lives. Recovery is possible, but it's only possible if the individual is alive. We have to save them first. Thank you.
That completes our 5 minutes. So, no, please at least come up and say who you are and that you support the bill.
Mr. Chairman and members of the committee, Allison Powers from the Indigent Defense Commission.
Thank you very much.
Mr. Chairman and members of the committee, my name is Julie Funkhauser. I'm in long-term recovery, and I'm from Winchester, Virginia. I lost my husband in September 2018 as a result of an overdose, and his cousin 2.5 months later, both situations in which they could have been saved because they were left. Thank you.
Thank you very much. Please come forward.
I'm Mary Ann Burke, and I helped found Change Addiction Now, a nonprofit for parents who have children in addiction. I wanted to make one point, and that is...
We really, to be fair to both sides, we don't want to extend. Go ahead. Thank you.
Thank you.
Thank you.
I'm Alan Ludis. My daughter almost died from an overdose when her friends, quote-unquote, dumped her on a lawn and left her because they were afraid contacting 911.
Thank you very much.
She survived.
To all those who just spoke who are in recovery, that is a process that you have to start again every morning. And as someone who has lost an immediate family member to overdose, their substance was alcohol, but there is nothing that is more important to me but the issues that you guys deal with every day. And it takes a tremendous amount of strength to be public about such a thing like that, let alone to come here and testify and share your stories. And I'm deeply grateful. All those against this bill, please come forward. Once again, we'll put 5 minutes on the clock, just remembering that the people behind you have less time with the time you use.
I can feel the daggers. My name is Michael McDermott from Maiden, Virginia. I suffer from a disease from which there is no known cure. However, it can be arrested at some point and recovery is impossible. I've been in recovery from substance use disorder for over 28 years, and I'm here today not to count my days, but to make my day count. Just to level set real quickly, you made reference to Delegate Carr's bill, HB 532. This bill is very similar. And I also want to level set about a remark that was made about receiving emergency services and being streeted. I'm sure a lot of people are aware of SB 903. And the summation of that is that it provides emergency treatment to an individual experiencing a substance use-related emergency to establish and implement a protocol for connecting such patients receiving emergency treatment with appropriate community-based providers of behavioral health services upon discharge. That passed the Senate 40-0. It passed today in the House 80, okay, unanimous. It's going to the governor for signature. So we have something in place to protect the overdose victim, okay? The fact that this is called the Good Samaritan bill, I think, is misnamed, because we want to protect the Good Samaritan, okay? We don't want to protect the victim from the legal ramifications of what they've done if they're probation, parole violation. And for that point, you know, I think it's got good intentions, so I'm not totally against it, but I think it needs to be amended to only protect the Good Samaritan and not the victim. There's no guarantee that an overdose victim treated by paramedics will find recovery. So, thank you.
Thank you very much.
Mr. Chairman, Derek Davis on behalf of VACA. We recognize there is an opioid epidemic that is hitting the Commonwealth hard and people are dying, and we want to solve this issue, but we don't agree that this bill is going to do that. We take issue with changing it from the affirmative defense to now an immunity. The bill is in place now as it is. The Good Samaritans are protected. They have the affirmative defense. So we have a very successful drug court program that we use in my jurisdiction, and nobody ever says, hey, they got a good program down there, drug court, let me go down and check it out. They have to come into contact with some sort of law enforcement into the system so that they can be ordered treatment sometimes. Sometimes the interaction with law enforcement is the wake-up call they need, that it's time and they've made the decision that they want to get clean. For so many people we see, the access door for recovery is the front door of the courthouse. And again, changing this to immunity from an affirmative defense, I keep seeing this scenario. Police and medics are called out to a scene, 2 friends there, one overdosing. The one friend is hauled off to the hospital where maybe he dies, maybe he doesn't. And so then, because there's immunity, there's no crime to investigate. So at that point, the officer can't even take the drugs out of the house. So you have medics and deputies saying, all right, have a nice day. And then you've got the other person sitting there with a pocket full of heroin still in this stressful situation. They just watched their best friend overdose. So what do you think is going to happen in that situation? You're probably going to be back there the next morning with another victim.
Thank you very much.
Thank you.
Got a $1.20.
$1.20. My name is Mike Feim. I'm a deputy Commonwealth attorney in Henrico County. I've worked in the criminal justice system in some setting for the past 26 years. My first 7 years of my career, I was a public defender and defense attorney. The past 19 years, I've worked for Henrico County. I'm the lead drug prosecutor for Henrico County. I've seen every day of my professional career the scourge of drugs and what this is doing to my community. I'm strongly against this bill because people will die as a result of this bill. I have learned more than anybody in this room the effects of drugs, what the effects they have on the brain, and how people act who are addicted. People at the time that they interact with do not make rational decisions at the time that they interact with police, the time they're arrested, the time that help is being provided for them. People do make rational decisions when they go through recovery. I have many friends in the recovery community here, and we are making significant progress in this. The second problem that I see with this case is that it's going to preempt a number of situations where the government can provide help and work with folks. One of the situations where preemption is going to happen is in cases where we are investigating a death. If we cannot motivate people to cooperate with an investigation, we're not going to get to the source of the drugs that are causing the death. Another scenario that's going to happen is if for example, McDonald's manager calls and finds somebody passed out in a bathroom, there's no motivation there for that person to cooperate.
Thank you very much.
Mr. Chair.
Delegate Herring.
Thank you. I have a question for the
Yes, ma'am.
I just want to make sure I understand what you said, that if someone calls for help, is that what you said, that they're not being rational?
No. The person calling for help is not being rational. And I'm not saying that all people in the throes of addiction are not rational. What I'm saying is that based on my experience, because of the effects that narcotics usage, drug usage has on the brain, people don't make rational decisions at times. For example, get help. Participate in this program. Stay in this program. That decision is not always the rational one that's being made, and it's due to the effects that narcotics have on the brain functioning. It doesn't make them a bad person, doesn't mean that their decision-making is disturbed throughout the course of their entire life. It's an effect of the brain, of the drug usage.
So, and Mr. Chair, another question.
Please, go forward. Madam Chairwoman.
And I want to make sure I understand your testimony, which is that people will not go for treatment or help unless there is a
I'm not saying that.
That's what it sounded like. It said unless there is an ability to bring a criminal charge, they will not access help.
Sure, that's too generalistic. And obviously, that's not
so.
The case.
What were you saying with your point?
I'm saying oftentimes people don't stay. People go into a recovery situation and they don't stay in that recovery situation because of a number of factors, and one of the factors being the lure and the desire to go out and get more drugs. And we see it all the time in our court system where the judge will release somebody and say, we want you to stay at this program, and 2-3 days later they leave the program, we lose touch with them, we don't know where they are, we come back to court and they're not there. Obviously it's not going to apply in every situation, but it is very frequent that we have that problem. Oh, did I answer your question?
I got it. Okay. Thank you.
Delegate Scott and then Delegate Carol Foy.
You said you're a prosecutor and you used to be a defense attorney?
That's correct, sir.
Huh. Interesting. So, and I say
I did my career backwards, didn't
I? Me too.
And I ask because I do this, and people who are in the throes of addiction, they are rational enough to call for help, which is what this bill is about. It's not about making sure that we got more people to prosecute and threaten into recovery. We want folks to make the choice when they are, as you say, rational, to go into addiction. But what I've seen, even with drug court, people fail often in drug court.
Yes, sir.
And then they come back, and then they fail, and then they come back. And so that's what we're trying to do. We're trying to put people in a position where to be successful, but that is not what you're saying here. All we're trying to do, I understand it's in the Boyce Code, is save lives, to give people the opportunity to be able to call. I don't think anybody who's in the throes of addiction and they all getting high together, they're not worried about necessarily drug treatment at that time. They're worrying about, can they call their friend some help without going to jail that night? I'm not sure if they need help or not. They may come out of it. I'm not sure, but I don't want to take that risk. I want to be able to stay with them until law enforcement comes to save a life. That's all this bill is about. Can we get this thing out?
Delegate Scott, I do understand your comments, but let me say in response, how do we get somebody who has overdosed into drug court? And drug court is one of these most significant achievements that we've made in the field of addiction.
Okay.
Never mind.
All right.
May I respond, Mr. Chair?
Yes, you may. But
I guess I'm not getting through. We're talking about apples and oranges. Apples is drug court, great program. The other Commonwealth attorney earlier talked about people stealing all the time with these drug problems. So you should be able to get them in drug court when they steal.
Okay.
Let's not try to put them in drug court when they call in to save somebody's life.
All right. Delegate Watts. And before we go any further, I want to remind everybody on this committee that every person on this committee voted to lay almost the exact same bill on the table, except for No, not Delegate Scott. Really? I thought it was
3-4,
no. Oh, well, all right. Never mind.
It's a motion now in order.
So, go ahead. So we've taken public comment. You want to?
Yeah. So partly because of the hour, but also make the motion to report and speaking to the motion. This time I'll do it right.
Thank you.
Okay. And speaking to the motion, I just want to point out that what we are amending here and giving this immunity is only the immunity for anything that is
Correct.
found as part of the call.
Correct.
Only that act, and only if the individual who makes the call fully cooperates with law enforcement.
Correct.
So it's a very narrow immunity that we're offering under this bill, and with that I have a definite comfort level that all of the other things that could trigger in the system are still very much potentially there to get people into the help that they need to seek.
Thank you.
So I this time I did it right. Move first.
So there is a motion that has been seconded, but Delegate Bell.
Mr. Chair,
Yes, Delegate Bell.
again, this might be for staff. Is there a requirement that they cooperate with the prosecution?
Mr. Chairman, that requirement was actually removed, I think, last year.
Right. Right. There's no
under the statute.
Okay.
And I apologize. You're right. It was 5-3. There's a motion and a second to report. All those in favor indicate so on the electronic voting machine. The bill reports 5-2.
Thank you so much.
So, Delegate Serval, did you want to try and... Sorry. Senator Serval, did you want to do yours now or on Monday?
No, now.
Okay. SB 492.
My wife says I don't need to be home till 7 for my daughter's birthday party. So.
That's hopefully when I'll be home for my son's birthday.
Okay. So, Mr. Chairman, this bill does two things. First of all, it corrects, I think, what was an error in Delegate Freitas's bill last year that the Supreme Court identified. And that's what the first part of the bill did. So just so the non-lawyers have an understanding of what this does, if you're required to register on the if you're required to register on the sex offender registry, there's two types of registrations. There's sexually violent registrations, which require registration every 90 days, or there's just sex offender registration, which is like, I think, once a year. Okay? And Delegate Freitas passed a bill last year which talked about out-of-state convictions. And the problem was the way it was written, you could be convicted of an offense out of state, which is not classified as a violent offense in state, but you get treated as a violent offender in state because it was out of state. And the Supreme Court wrote an opinion about this, affirming a conviction of a guy, and called it an absurdity. And this bill corrects that. So what the bill does is it says you only list as a violent offender if you're classified as a violent offender under Virginia law, or if you were classified as a violent offender in whatever the state was you were convicted in out of state. So it makes I think it affects what our intent was.
Chair, so I'm not. I don't know how I feel about this, but I'm not following what he's saying. Could you either slow down or use in-state and out-of-state a little more?
Because
about what the bill does?
If I'm not following my usual rule, is somebody else in this room is not quite getting what you're saying. So if you
the bill actually does two things. So
and I haven't got to the second thing yet.
Okay.
The second thing's at the bottom. I'm just focusing on the first thing.
Yeah. Can you try a different way?
So the first thing, the summary of what it does.
Use examples with names or something. Just simplify. I'm sorry.
Well, it says if you pass this, what it says is you register as a violent.
Mr. Chair, I'm sorry. You're doing okay. I was losing track of the in-state, out-of-state, and everything else. Just tell us current law. Tell us how it changes, if you would. Just so I'm not following.
Current law says basically that any conviction out of state is treated as a violent offense for listing purposes in state.
Okay.
And that's not what I think we intended. This would change it to say an out-of-state conviction is treated as a violent offense if it's classified as a violent offense under Virginia law, if it's substantially similar to a violent offense under Virginia law, or if the state you came from treated you as a violent offense under that state's law. Right now, everything from another state is treated as a violent offense. And the Supreme Court called that absurd. But they said that's what the law says, so we have to enforce it that way. So that's what the first part of the bill does. Counsel can correct me if I'm wrong, and I can shoot you the opinion.
We'll get to
Mr.
Mutnick in a second. Just
okay.
Do your thing.
The second thing the bill does is it adds an at-liberty element to the ability to petition to get removed. So right now there are certain people who cannot petition to be removed from the sex offender registry. Sexually violent felons is one. But it's also people who have been convicted of any two offenses that require registration. And I'm adding an at-liberty requirement, so you would have to be convicted of two offenses but be at liberty between the two. And the reason for that is I think it's fundamentally unfair for you. The way prosecutors often will charge people is they'll load them up and they'll charge them with multiple offenses for one incident. And from my perspective, I think what we had meant to say, but I wasn't here, is that you had to be at liberty between the two incidents to be not eligible for removal from the list. This doesn't remove anybody from the list. It just says they can petition to get removed. So, so that's the two things the bill does. The Supreme Court brought one to my attention, and the other one was brought to attention to me because I just think you ought to be able to petition to get removed if you were convicted, unless you're at liberty. You did it twice while you were out of jail. I think that I can understand that, but two from the same incident to me is not an appropriate standard.
Okay. Mr. Mutnick, I am loath to ever open up this statute because I'm always terrified we'll get something wrong.
Yeah, we just did last year when we passed Freitas's bill.
And that's why I'm loath to open it up.
Mr. Chairman, the case that he's referring to is Turner v. Commonwealth. Virginia Supreme Court was interpreting, and it was actually a conviction for failing to register as a violent sex offender, and the defendant challenged whether or not he had to register as a violent sex offender because his conviction from Idaho was not violent. The Supreme Court did hold that we conclude that he was required to register as a sexually violent offender in Virginia because he was required to register as a sex offender in Idaho. They did not go to the absurdity language because they were bound by the plain language of the statute. And so the defendant had argued it was absurd, and they said they didn't touch that because it was plain language. We don't have to get to that part. So that is the statute. That is what the Supreme Court held. So that if you are required to register as a sex offender in another state, you are required to register as a violent sex offender here in Virginia, whether or not your conviction is violent.
Thank you, Mr. Mutnick. Delegate Delaney, Delegate Bell, Delegate Watts. Nope. Delegate Bell, Delegate Watts. Oh, no, Delegate Delaney.
Yep,
Go ahead.
Okay, thank you, Mr. Chairman. So the victim population that this affects is one that I'm particularly protective of. So I have more comfort with the first part of this bill if you're saying that you are if you're violent in another state, if it's considered violent in this state, then you would have to register in this state as violent. And so let me just clarify: if somebody is registered as nonviolent in another state, and then they come to Virginia, they would still be required to register, but just not as violent. They would be it would transfer identically
If you pass this.
if this passes. So that part I understand, and that doesn't give me much pause. I do have concern, I think, with the second half, and what I want to understand is I see the difference between separate incidences. You're charged with one, and then it happens again. You're charged at a later date. Wouldn't it be accurate, though, that the reason why they're stacking charges is because there's multiple offenses? I mean, if you have one offense, are you being charged multiple times for that one offense, or are you being charged because you've done something several times and now you're being charged several times? And I guess what I'm getting to is one time is bad enough. Doing something multiple times is a certain level of predator that I don't care if it happens between convictions or not. I'm more concerned with if you're someone who's going to do something multiple times, that is what in my mind is putting you in that category. It doesn't matter the timeline, how it affects to the court system.
So, Senator Serval, I think I share Delegate Delaney's concerns. Like the first half, not so happy with the second half. Delegate Watts.
Did it again. Mine was a technical question of counsel about the second half. As you recall, I had a bill that was multiple misdemeanors on 3 or more, and I now know that there are 4 and then possibly 5 if my bill survives the whole route. So on the language, which is 2 or more offenses for which a registration is required, and I realize that's existing language, does that at all conflict with the third offense that puts you on the registry? And might that word, rather than offenses, be violations for which you must register?
Madam Chair, that would be, the offense would be the third offense, which is the one that requires registration. So it would not apply to the first 2, but only if you had multiple third offenses would it apply.
Okay, thank you.
All right. Anyone here who would like to speak in favor of this bill?
Can I just speak to what Delegate Delaney said?
Yeah, can we just take public comment and then you always get the last word. Anyone in favor? Anyone opposed?
Nobody's testified at all.
Nope, nobody has any testimony. So, Senator Sorrell.
Yeah, so remember, this doesn't tell a court they have to delist somebody. It just says that they can petition for it. And if they committed some particularly violent offenses, I don't think a judge would delist them. You got to remember that
a judge doesn't have the authority to do that in the fashion that you're describing. That is done by the state police.
No, you petition to the court.
You're talking about at the time of conviction. There's a separate petitioning.
No, I'm not.
Right. No, I understand.
I'm talking about years later. You come back and you petition to be removed from the list.
Okay.
But the there's different kinds of offenses we're talking about here. They're not all necessarily people touching people. I mean, it could be something that happens on the internet, right? For example, right now if you open your pants in front of a live child, it's a Class 1 misdemeanor. But if you do it on a video cam to an undercover cop, it's a 5-year mandatory minimum felony. So you could have multiple, exposures on an internet camera over a computer, right? That's obviously not, I think, as serious. It's serious, but it's not as serious as an actual touching someone, right? And so the way, prosecutors will often load people up with charges to get them to plead, and then a lot of times they'll make people take multiple convictions out of the same incident. Partly, by the way, because Commonwealth Attorney's Office's funding is determined by how many felonies they charge and how many convictions they get. Right now,
that's going to be investigated and
probably
changed next year.
I know, we're studying that.
So, and remember, this doesn't change that.
I know, but
so. Okay. There is a motion and a second to report.
Mr. Chairman, can I speak to the motion?
Would you please?
I will only be able to support the bill if we sever the second half. I'm just not comfortable. I hear what the senator's saying, but to me, it's the fact that it's multiple offenses.
Is that a motion?
So I don't, I'm stating if somebody's doing the math, I'll support the bill if it's the first part.
Okay.
But I'm just not comfortable with the second part.
Is that a motion?
If I don't know how friendly the senator will consider that on the scale of how friendly I've been to the senator today.
It's a keep me alive.
Mr. Chair.
Motion.
Delegate Bell.
It's 5 o'clock on a Friday. Can
we are
withdraw
going.
What's happening?
So.
She wants to strike lines 29 to 151.
Right now, we have a motion before us, which I would entertain a motion to withdraw. Yeah, which is now withdrawn by the requester. Now there is a subsequent motion by Delegate Delaney, seconded by Delegate Scott, that we strike the second portion of this. So, I remove the new language, really, in that second portion. So. All those in favor, please say aye. Aye. All right. Now we have the bill before us.
Second.
Move to report as amended. All those wishing to do so indicate on the electronic voting. Sorry? Is it oh, no, it's a substitute. Sorry. Yeah. There you go. The bill reports 5-2. Now we have two, I hope, quick and easy ones. Senator Suderline and Senator McClellan both have, I think, easier ones. Who is here first? Who wants? Yes, you do. All right. Come on, 215.
Thank you, Mr. Chairman. I hope that comment means that you're favorably inclined for the bill. Either way, it should be a quick decision. You either like it or you don't. It's Senate Bill 215. This deals with the Board of Corrections and their review of jail deaths. The relevant language for you to direct your attention to is lines 43 through 47. In it provides that the board shall publish an annual report summarizing the reviews of the jail deaths that they conduct within the previous year. And in the report, they're supposed to be examining trends or similarities among the deaths of inmates in local correctional facilities and present recommendations on policy changes to reduce the number of deaths, and it's a public report that'd be on the website, and also on the. It was requested by the chair of Senate Rehab that she be added to the report, and also your chair of Public Safety. I don't really care where the report goes. I just want the report to occur.
Okay. Do you mind? I would entertain a motion. I know that Chairwoman Herring and I would both like to see this information too. So I'd entertain a motion to include the Chair of Courts.
So moved. Second.
There you go. All those in favor, please.
Aye.
There you go. All right. Well, let's just make sure we take public comment real quick, but I think you know where this is going. Yeah. You know what? We should start calling her Uber Chair. Yeah, I like that. Anyone who'd like to speak in favor or against this bill? It's a good bill. All right.
Second. This was only put on the books in 2017. I think it was assumed.
Yeah. Thank you. The clerk will close the roll. Thank you very much.
Thank you, and thank you, Sarah McClellan, too.
And Senator Chafin also is going to be the last one, so please come on up.
Good evening. I have Senate Bill 711, which would eliminate the 10-day mandatory minimum jail term for a third or subsequent offense of driving with a suspended license for those offenses under 46.2-301, and that's the bill.
Senator, I said this earlier when you weren't here. I wish I had carried this bill myself.
If you had, I probably wouldn't have had to show up, so.
Yes. All right. All right. Is there anyone here who would like to speak in favor? Hey, Ms. Woolard, please come up.
Mr. Chair, committee members, Amy Woolard with the Legal Aid Justice Center. In the hopes that brevity is the soul of a positive vote, we support the bill.
New Virginia Majority.
Dominique Martin, policy analyst, and echo the previous sentiments.
Anyone who'd like to be? Is there anyone opposed? Delegate Bell. And Delegate Bell is.
I'm going to vote no, but I don't want to talk.
Okay. All right.
The Commonwealth's Attorneys
Talking too much on a Friday, but anyway, why no one's opposed is quite interesting to me, because one of the reasons why mandatory minimums appeared in drunk driving is because too often the bench would not convict the nice, I'll be blunt, nice white guy who's just made a little mistake. And so I just find it interesting that it's felt that justice will be even-handed across all categories, and that there's not a concern about doing away with the mandatory minimums when there was too much leniency in certain courts.
Delegate Watts, I actually anticipated you would ask a question similar to that, and so I just wanted to say this doesn't deal with DUI offenses at all, and that's why no one raised that concern.
All right, thank you. Appreciate that.
This is just under 272.
Correct.
Thank you.
Oh, and I'm sorry, 301. Apologize. Committee operates by motion.
Move the report.
Second.
There's a motion and a second. All those in favor or against indicate on the electronic voting machine. All right. Nope. Close the roll.
Thank you, Mr. Chair. Have a great weekend.
Yeah, the bill reports 5-1. It's good to see you. Senator Chafin. You will not be the last, though. Senator Howell will be after you.
Thank you, Mr. Chairman, members of the committee. So I'm back before you on Senate Bill 1003, and there is a substitute.
I was hoping you would say that. Let's take a look as the clerk is distributing. But we've just spent so many days at this point dealing with computer trespass related things in this committee for 6 or 7 years. It's always entertaining to see actually new language, so I appreciate that. Mr. Munich, can you walk us through? Oh, first, is there a motion to adopt the substitute?
So moved.
Is there a second? Delegate Scott, is there a second?
Second.
Thank you. All those in favor, say aye. Aye. There you go. We are now before us with the substitute. Maybe, Mr. Mutnick, you could walk us through a little bit of the substitute? It's a lot shorter.
Mr. Chair, what the substitute does is it brings the language more in line with some of our current code. Instead of using a computer that's internet capable, we'll use electronically transmitted communication, which would fall both with computers and also text messages or anything sent with a smartphone or an iPad. And it moves the language to the beginning of the intent to receive any direct or indirect, without the intent to receive any indirect or direct benefit. And then it has a malice element as well, which I believe was in the bill before. Still has language that we don't have anywhere else in the code, which is the part about on line 12, intending to cause another person to spend money. As the discussion that we had at the last hearing about fraud and how all of our fraud statutes really require somebody to part with their money and enrich the person who committed the fraud. So this is a new concept, but everything else the substitute brings in line more of the language that we already use.
Thank you, Mr. Mutnick. Is there anyone here from the public who'd like to speak in favor or against this substitute? Seeing none, is there any discussion from the committee? Delegate Bell.
Mr. Chair, I'm more worried about the term spend money. I just did a quick, well, I know, but can we use something that's used someplace else so we don't have to develop a body of case law? I'm looking at the false pretenses. Money, a gift, I'm just other property, just something, part with.
It's Bitcoin money, there's 10,000 things that could be litigated.
No, right, I just don't want to do just something new.
No, I understand. I'm translating a little bit.
Unless this goes to conference, we're the last ones that'll look at this, and we're about to create some.
I can't imagine that this will go to conference. I don't think there's
that's what I mean.
anything to conference.
I think that we're.
So, Mr. Mutnick, is there a term other than spend money that we could use, that we find throughout the code? Or Ms. May, actually, it looks like she is racing through code and similar code sections.
Mr. Chairman, part of the problem with using that, and there are other terms we could use, we could take the language from 182178, which is money, a gift certificate or other property that may be the subject of larceny. But part of the problem in this is that you're not actually causing them, the crime is literally causing them to spend money, because you're not bringing property from their possession to your possession by fraud. You're causing, the example that was given is you're causing this person to buy a plane ticket or travel and use a hotel. And so to get to the concept, there really isn't another, because it's a new concept in Virginia law, there really isn't another word that we could find that goes to that. Because it is, in fact, a concept that we don't have anywhere else in our fraud statutes.
And courts have been very good about defining terms previously.
Mr. Chair, I'm not worried about the money. That's I think case law says that means, different kinds of money, credit card, checks.
Yeah, fungible.
It's the spend. And surely in 401 years we have come up with something. I don't know. What if you loan it? What if you disperse it? What if you buy something of value, but it's not as much value? Can we?
Delegate Watts.
And don't forget, it's not just obtaining property. You could be employing somebody, and you're spending money for protection or whatever.
This section is always tough.
We were stress testing this, staff and I, at one point, and person says that there's crystals under the earth, and if you take your sick kid there, your kid will become well. And he does it maliciously because he just wants to be awful. A TV preacher who says, if you just send me, we had a palm reader in Charlottesville that said if you gave her cash and she buried it in her yard, it was a sick child scam, your sick child would get better. Now she's serving federal time right now because she was the beneficiary. What you're talking about is trolling, or just people that hatefully want to do something. Right. And he's tied it to money, so I think that this is viable and this is a doable thing.
The actual definition the definition I'm reading off the internet of the verb spend is pay out money in buying or hiring goods or services. And we could put that whole thing in there, including the word spend, because it does say, so you could say spend money in buying or hiring goods or services, or pay out money in buying or hiring goods or services, which is buy out is a little different from spending in some.
And I'm not trying, spending is as good as any other word. I'm just saying somewhere in the code there's a bunch of cases interpreting something that we've surely don't need to start a new tree here.
No, I understand, but this is a new concept, as Mr. Mutnick was saying. I'm not crazy about using new terms either, but I think I'm comfortable at this point with the work that our attorneys and Senator Chafin has worked with. So at this time, committee operates by motion.
Second.
There's a motion and a second. All those in favor indicate so on the electronic voting machine. Your bill reports 5-1. Thank you, Senator Chafin.
Thank you, Mr.
Good luck on your
Chairman.
drive home.
Members of the committee, thank you.
Now, I understand that there are some members of the administration or someone who will be coming to present on behalf of Delegate. Mr. Secretary.
Mr. Chair, nice to be with you. This is a lengthy bill, 579.
This is a terrifying bill, so
but
we have a cheat sheet.
The substance is such that it really is not. And so, I know. Well, this in comparison to all the legislation you've been passing is really quite mundane. So,
So we
have an amendment in the nature of substitute, SB 579. Yeah,
which we should all have in front of us.
I have the state police here. What essentially?
Hold on, we just need to get the sub in front of us.
Okay.
Yes. All right. We have to move the substitute at this point. Is there a motion and a second?
Second.
There's a motion and a second. All those in favor say aye.
Aye.
All right.
Mr. Chairman, members of the committee, it really is a kind of an origin of two different parallel paths, one of which we, in the Secretary's office, we were getting a lot of calls with respect to how people register. We asked the state police to conduct a study, see how we can just make it more efficient without changing any policy. And at the same time, Senator Howell was pursuing a study, a more comprehensive study of the sex offender registry. That we have not conducted, but what we have presented is one that is a bill, though lengthy, merely just tries to create some efficiencies in terms of language. For example, we established 3 tiers as opposed to using terms such as sexually violent, but we don't change the terms of what categories of crimes are in the tiers, nor do we change the times that you can be removed from such tiers. And so, but before I go any further, I'd just ask the state police to kind of walk through any particulars or answer any questions. But it really is merely designed to create some efficiency.
While that's happening, can you distribute that little cheat sheet that was sent to? Can you print it out just so that other members can, as the state police is walking us through this, we also, we had some wonderful attorneys who put together a excellent cheat sheet that's only like 2 pages instead of the 57 that it is currently.
Good. I don't know what's on this cheat sheet, but hopefully I'll assume
just
that
describes
is absolutely accurate. Yes, good.
Please come forward.
Good afternoon, Mr. Chairman, committee. Eric Goen with Virginia State Police. I'm currently in our CJIS division. Just to cover a little bit of Senate Bill 579, which we worked with Secretary of Public Safety on. The bill, currently in the state of Virginia, sex offenses are classified into 2 sections, 2 categories, sexually violent and nonviolent. There are nonviolent offenders that may petition to come off the registry in 15 years, nonviolent offenders which may petition to come off the registry in 25 years, and then violent offenders are required to be on the registry for a lifetime. If you look at the SORNA, the federal code guiding the sex offender registry, you'll notice that their classification of sex offenses is broken down into tiers. It's a tier 1, a tier 2, and a tier 3 system. We have mirrored the titling of that, our offenses, to mirror tier 1, tier 2, and tier 3. What this does is it takes Tier 1 offenses, it makes those sexually nonviolent offenses, which may petition to come off in 15 years, it retitles them to a Tier 1 offense. Sexually nonviolent offenses, which may come off in 25 years, are retitled to a Tier 3, and sexually violent offenses are retitled to a Tier 3. 25 years for petition is titled as a Tier 2. Pardon me. So that change will mirror the tier system that's currently used in the federal system under Sex Offender Registry and Notification Act. The bill also removes the constant re-registration annually for Tier 1 and Tier 2 offenders because under our operations, we in-person verify Tier 1 and Tier 2 offenders by annually in person with our compliance officers and Sex Offender Registry troopers.
Thank you very much. We're keeping all of the schedule that Delegate Watts did in 2009. That remains under 9.9.1.104. We are not changing any of the petitioning timelines. The old subsection B is now Tier 1. The carnal knowledge, distribution, all the solicitation of minors under the internet, that's now Tier 2.
Yes, sir.
And the new Tier 3 is the old sexually violent offenses.
Yes, sir.
Okay. So I want to draw your attention in the substitute to one line, and I just want to sort of get your feel on it. The only thing new that I can see in this was something that was brought to our attention by some of our brilliant lawyers, which is on 352 and 353, we now have a new 2-year requirement that we did not have previously. Now that's a policy decision I think is all right in my mind, but I just wanted to find out a little bit more about what we're doing. So this is, just so everyone is aware, this is under 9.1.903, sex offender required to register. We're talking about authorizes a business. It's the consent form.
I believe that's currently included in 9.1904.
It is.
Section A of the current law.
I'm looking to Mr. Cotter.
408, Mr. Chairman.
408.
Wow, this is like old times.
Man, it's always great having you here.
1999, we're partying like it's 1999. Look at this.
You know what? All right, well, Delegate Watts.
So what I was looking for was repeatedly over the years, issues have been raised about accessibility for those who really want to follow all of the steps, and that depending upon where they are in the Commonwealth, 24/7 is not something that's readily available, as well as issues, and I'm not even close to a Cotter, to find where we're talking about what you're supposed to do if you change your email address, and that's supposed to be immediate. Did you address those kinds of issues which have been repeatedly raised?
Yes, ma'am. We did not address those issues in the bill as far as, I believe you're referring to the outreach and education of the offenders. But we have taken steps to improve our communication through our area offices. We currently produce a brochure which details out the steps for the registrants to come into compliance. Last year we developed the email system for which registrants can email us to notify us of a change in their electronic databases. So internally we have worked to develop policies to improve our communication to our registrants. In addition to our helpline, which is staffed during the week, registrants can report to our area offices located throughout the state where they can be registered by our staff. We have compliance officers on staff that if a registrant, for example, calls us and lacks the capability to drive, for example, we've experienced that. We will send a compliance officer or a trooper to them to ensure that they are in compliance after they notify us. So while we did not address it in this bill, we are internally making strides and efforts to address it through policy, to address the ease for which the registrants can remain in compliance.
Okay. One further question. So your response gives me some comfort, actually, in an odd way, both that you're trying and that you're not declaring that you have addressed it. So if there are still problems, it is open then under this, as I understood it last year, the new contract to try to get a system that the communication that I think you're saying is communication not only you with them, but they're being able to communicate with you, yes. That this is still perhaps an open question once this system gets up and running as to whether or not there needs to be a more seamless way of compliance so that we don't have gotcha situations. And then I will final ask a question, which is how many offices do you have throughout the Commonwealth? In other words, how close are people to these offices?
Well, they can register at any local sheriff's office, police department, or Virginia State Police Office or our division headquarters. And I don't have that number right off the top of my head.
And I will follow that answer then with it has been brought to my attention that this is another thing you need to be focused on, that not all local sheriff's office, police departments are really geared towards following the steps that need to be taken for compliance.
Thank you, Delegate Watts. Mr. Mutnick, go one last thing.
Mr. Chairman, I wanted to just point out, you had mentioned the 2-year thing. There is, on line 402 and to 406, the old law was that a person had to do the consent form upon registration and as may be necessary. The 2-year difference that's added to the bill now is they have to do that every 2 years now. And so the photograph hadn't changed. That's every 2 years, but that part is. So I wanted to point out that Mr. Cotter was wrong.
I love this committee.
Let's get ready to rumble.
All right. So the committee acts by motion.
I've been taught well.
Mr. Cotter says, let's look at line 421. He means 422.
But that's not the consent form that we're speaking about.
I love a good fight. All right. At this point, the committee acts by motion. Oh, I believe we have already moved the substitute at this point.
There's not a substitute.
Oh, this is.
There's been a motion to report in second, I think.
There you go. There's a motion. All those in favor indicate on the electronic voting machine. No, we don't. The bill reports 6-0. I want to take a moment before we gavel out the last meeting of the Criminal Law Subcommittee to thank everyone who has been with us.
Especially Mr. Carter.
Well, not just especially Mr. Cotter, especially for our clerk staff, our staff from Legislative Services, our attorneys. I could not be more grateful. We work harder and longer in this committee than any other committee, I would say, in the House or the Senate. While I'm very happy that our latest night was less than 11, it's not been unusual that we would go even later. Your work is tremendous, especially at the time when there has been more bills coming through this committee than there has been at any time since 2007. So thank you for sticking with us, and thank you for all the people who come and testify every day, every week, and spend all their time up here in Richmond. I also want to take a note for those who are watching. This committee has passed more progressive criminal justice reform legislation than this committee has ever done in its history. Massive changes to our jury system, to larceny, to marijuana, to how we treat individuals more fairly and more equitably. And when we began this committee, I told everyone that that is what we would do. And throughout this session, we have worked tirelessly to be able to do that. And you will see in the next 5 months the largest changes to the criminal justice system that have occurred ever. So I want to thank everyone for your work you've done, and I know that we'll have even more work to do in the future. Thank you all.